Good morning, student. I trust that you're doing well. Today, we are continuing with a summary of the variable consequences of the civil marriage, specifically concentrating on marriage out of community of property. Just to recap, in my last recording, I spoke about marriage in community of property, which is the default matrimonial property system when spouses get married without entering into any other agreement. Marriage out of community of property. In order for spouses to get married out of community of property, they need to sign a contract called an antenuptial contract. An antenuptial contract is a written agreement where prospective spouses exclude all or some of the common law and statutory consequences of their marriage regarding the matrimonial property system. The contract must be concluded and registered at the deed office before the spouses get married. When entering into an out-of-community of property marriage, there are three options that the spouses have. The first option is out-of-community of property without the accrual system. This is known as complete separation of property. Under this system, each spouse retains their assets and monies. In other words, they retain their estate that they acquired before the marriage and that they acquired during the marriage. That is complete separation of property. The second option is out of community of property with retention of community of property and laws. Under this system, each spouse retains their assets and liabilities that they had when they got married. And upon getting married, all the profits and all the loss, in other words, all the assets and all the debts that they acquire during the marriage are shared jointly. And the last option, which is an option that we're just going to talk about it in detail, is out of community of property with the accrual system. Out of community of property with the accrual system entails that during the marriage, the spouses have separate estates. They have their separate assets, they have their separate liabilities, but at the dissolution of the marriage, whether through divorce or through death, the spouse whose estate is lower get to have a share in the other spouse's estate. In other words, they get to share half the difference of what has been accrued from the other spouse's estate. And the only thing that is shared is the monetary value of the assets. There is no sharing of debts at all. In all these three options, there is no sharing of debts at all. Except with the second option. Remember, out of community of property with retention of community of property and loss, it entails that the liabilities and the assets that the spouses had before they got married, they remain liable for that, for the debts, or they get to keep their assets, but any assets and any liabilities that was accumulated during the marriage gets to be shared jointly. So with out of community of property with the accrual system and with complete separation of property, the spouses do not share any liabilities. In order for the spouses to have a recognized antenuptial contract, the antenuptial contract must be entered into before the marriage. It must be in writing. It must be signed before a notary and two witnesses, and it must be registered at the deeds office. Let's move along. If an antenuptial contract is not properly executed and not registered at the deeds office, it is not binding on third parties. Please note this, and this is in terms of Section 86 of the Deeds Registries Act. So it is important that an antenuptial contract is registered at the deeds office if the parties want, or the spouses want it to be, if the parties want it to be binding on third parties. A quick summary of out of community of property use accrual. During the subsistence of the marriage, spouses have separate estates and can independently manage their estate without consulting the other. At the dissolution of the marriage, the parties share in the growth of their estate. Accrual claim. A spouse whose estate shows no claim or a smaller accrual acquires a claim against the spouse whose estate has shown a larger accrual. The claim is for an amount that is equal to half the difference between the accrual of the respective estates. The net in the antenuptial contract, the spouses must indicate their net commencement. In other words, it must be included the net commencement value. The net commencement value must be declared in the antenuptial contract or in a separate estate that is lost either before or within 6 months of the date of marriage. If the commencement value is not declared in the antenuptial contract, it is deemed to be nil, to be zero. The commencement value is also deemed to be nil or to be zero if the debts exceed the liabilities, if the debts exceeds the assets of the parties. It is important to know that accrual is the amount by which the net value of the spouse's estate at the dissolution of the marriage exceeds the net value of the estate at the commencement of the marriage. There is a difference between accrual sharing and sharing of assets. The accrual system does not give the spouses the rights in each other's assets. Instead, the accrual system creates a contingent right. The accrual system does not entitle the spouses who have the accrual claim to the assets of the other spouse. That spouse whose estate is lower or whose estate is nil has a monetary value. In other words, they can claim a monetary value of the accrual of the other spouse. When the accrual is calculated, the net commencement value is adapted in accordance with the weighted average of the consumer price as published from time to time in the Government Gazette. The net commencement value must be adapted according to the weighted average of the consumer price index. The net commencement value of an estate must be expressed in the value of the money at the dissolution of the marriage. So in other words, when you calculate the consumer price index, commonly called CPI, you firstly need to know how to calculate it. So the commencement value in the, to calculate the CPI, the commencement value in the antenuptial contract is multiplied by the average CPI as a date of the dissolution of the marriage, and it is then divided by the average CPI at the date of commencement of the, at the date of commencement of the marriage. I have done an example using formulas, and if you need a summary of my notes, you can send me an email or at monaring, MONARKN @unisa.ac.za, MONARKN @unisa.co.za. There is a formula that I have drafted in my notes that shows how to calculate the CPI. Remember, the CPI, as you do the accrual calculation, the commencement value has to be adapted to the CPI amount, and you must know how to calculate the CPI. You also need to know how to calculate the accrual. Although in the exam, it is a multiple choice exam, so you will not be asked to show how to calculate the accrual. But as a student, and especially those who wish to specialize in family law, it is important that you know how the accrual system is calculated. In my notes, I have drafted an example of how to calculate the, I have drafted an example of how to calculate the accrual system. And just to briefly explain, you need to know that first, the value of the accrual is determined at the dissolution of the marriage. This is in terms, or this was confirmed by the Supreme Court of Appeal judgment in the case of Brookstein versus Brookstein. To determine how to calculate the accrual, you firstly, the steps that you need to follow, you firstly have to determine the net value of each estate, the net value at the dissolution of the marriage. In other words, when the spouses, let's say there's a divorce and they decide, the spouses have made a decision that we are now going to have a divorce, we are now going to terminate our marriage, then each spouse's estate must be determined as to what is the value. And then secondly, you need to determine the net commencement value of each estate, of each spouse's estate. Remember, here to determine it, you need to use the computer price index in order to have the amount adapted to the current market value. And after you have determined the net, not the net, the gross value at the time of dissolution or at the time of termination of the marriage, and you have determined the commencement value, you need to subtract everything that does not form part in the calculation of the accrual. So in other words, if the value of the estate includes everything that was excluded in terms of the will, that needs to be subtracted. If it excludes everything that is supposed to be excluded in terms of the antenuptial contract, exclude it before you do the calculation, so that you reach a net value, or a net value at the time of the dissolution of the marriage. Then once you have reached the net value at the dissolution of the marriage, and then you have determined the commencement value, you have adapted it to the current market value, you need to subtract, as I said, subtract the net commencement value of each spouse's estate from the from the value at the time of the ending of the marriage, and as I said, exclude everything that does not form part in terms of the parties antenuptial contract, or if we use the Matrimonial Property Act, items that need to be subtracted in terms of Section 4 and Section 5 of the Matrimonial Property Act. Once the above has been done, you will know each party's accrual, each party's estate accrual. The accrual of each spouse's estate will be determined thereafter. What you do is you look at the party's net commencement, net value at the time of dissolution of the marriage, and the spouse whose estate is lower or is nil gets to keep everything that is theirs. They are going to have a share in the other spouse's estate, because the other spouse's estate is larger. So how they're going to determine the amount, the monetary value that they're going to have a share, you are going to subtract the smaller accrual from the larger accrual to determine the difference between the two estates. Then you divide the difference of the two estates until you get half the difference. So let's say, for example, the wife's estate is sitting on 1 million and the husband's estate is sitting on 3 million. Because the wife's estate is lower, so you are going to say 3 million minus the 1 million of the wife's estate. The value amount that's going to be left is going to be 2 million, and you're going to divide the 2 million into two. The difference is going to be 1 million. So the wife will be entitled to 1 million from the husband's estate. Students, as I said earlier, that if you need a summary of my notes, please feel free to contact me, because I have summarized what I've just been telling you in a nice summarized version, which I think it will make it easier for you students to understand. You are welcomed to have my notes. Now we're going to talk about protection of a spouse's right to share in the accrual. If a spouse manages their estate in such a manner that it prejudices the other spouse, there are protections that the innocent spouse can make use of in order to make sure that they are not unfairly prejudiced. The spouse's rights in the estate is protected by through an interdict. In other words, a spouse can bring a high court application for an interdict to stop the other spouse from doing whatever they are doing that will prejudice the other spouse. They have a right to bring in an action in terms of the actio pollina utilis, and they also have a right to bring in a court application for an immediate division of the accrual system. As a general rule, the following assets are excluded from the calculation of the accrual. These are assets that are excluded in terms of an antenuptial contract, or any asset which the spouses acquire by virtue of their possession or former possession of that asset. Secondly, donations between spouses are not included in the accrual. In other words, assets that spouses have donated to each other, they are not included. Any amount that accrued to a spouse by way of damages other than patrimonial damages is excluded. Any inheritance, legacy, donations which accrue to a spouse during the subsistence of the marriage, or any asset which was acquired by virtue of their possession or former possession of the inheritance, legacy, or donation, except where the couple agreed otherwise in terms of their antenuptial contract. Any donations between the spouses, or I have stated that is not considered in their any donation between the spouses is also does not form part. I have included this above, and this as well. Any damages, in other words, non-patrimonial damages, do not form part when you calculate the accrual. Student, this was just a summarized version of an out of community of property. Please, although I have summarized this notes and although I've done this summary of the notes, it is important that you continue studying your prescribed textbook, you continue studying your study guide and all relevant tutorial letters and any relevant notes that you come across. Like, for example, if you want my notes, just to get a summarized version as to how this section works, especially out of community of property with the accrual system. As I stated in my previous recording, it is important that before you even start studying the different case judgment, the relevant case judgment, or just to know the different sections, just make sure that at least you've got a basic knowledge of how family law works. With what we were talking about, if you just have a basic knowledge on how the accrual system works, it's going to make it easier for you to actually do your assignment, to actually do well in your exam, especially considering that your exam is an open book, a multiple choice open book. Good luck with your studies. Good luck with the exam, and feel free to contact me should you need any advice or any clarification with what we spoke about this morning. My email again is monarkn@unisa.co.za. Thank you for this session, and the next session will be about changing the matrimonial property system. For example, if the spouses who are married in community of property want to change from out of community of property to in community of property, what is it that they need to do, or what are the steps that the law allows to do? Thank you so much, student, and good luck with your studies. Thank you and have a good day.